So good morning, everyone. My name is Naomi Birundu, and I'm the court assistant for this session. But just before we start, I'd like to invite Simon for the photo session, and then we can proceed.
Yes. Thanks a lot, Naomi. I would like all of us to open the cameras so that we can take a virtual photo. Yes, kindly let us all of us open our cameras. Yes, great. Okay. All right. I'll be taking the photo in, okay, let us wait for the others. Few seconds. Timothy. All right, okay, I'll be taking the photo in, you can smile in 1, 2, great. That's all. Thanks a lot.
Okay, thank you, Simon. So welcome to the third quarterfinals round of the Green Law Global Initiative Climate Justice International Moot Court Competition. The matter before this honorable court today is between the University of Zimbabwe, representing Azania, and Mentors Moot, South Africa, who will be representing CECA. The honorable bench for this session will consist of Judge Helen Omondi as the presiding judge, Judge B.O. Akango, and Judge Cynthia Odongo. So I will now respectfully invite the honorable judges. The court is now in session, and I respectfully hand over the proceedings to the honorable presiding judge.
Thank you very much, Naomi, and a very good afternoon. Greetings in whatever time zone that you're in. And I think we are already into the time that we ought to have started. So without further ado, I will then invite the parties representing Azania into the session. I trust that you have been briefed regarding the format that this stage takes, that it is not reading out your submissions, because we have already gone through that at the preliminary stages and are familiar with your arguments. This will be more of an inquisitorial conversation that we probe into certain areas just to get clarification and appreciate your understanding of the entire situation and the laws that are applicable. So I will invite my colleague judges to then take you through that. And so I will invite Judge Cynthia Odongo, who will be the first judge to pose the questions. And perhaps since we will start with Azania, I will just ask the counsel for Azania to introduce themselves and then listen to the question from the judge. Thank you.
Just a reminder, before you start, you'll be having 30 minutes each and 7 minutes for your final submissions. Thank you.
Thank you, Presiding Judge, for that introduction. I would like to introduce myself as Lauren Mkanana as the first speaker for Counsel for Azania. I am accompanied by my co-counsel, Ms. Kudakwashe Masangu.
Thank you very much, Team Azania. My first question to you is on sovereignty and trade. So you argue that the Textile Waste and Circular Economy Act is an exercise of sovereignty. So does international law permit a state to unilaterally impose standards that effectively dismantle a global value chain? Or does the duty of a cooperation cited in the ICJ advisory opinion require you to seek multilateral solutions first?
Thank you, Your Excellency, for that question. To answer you, we would like to cite the UN Charter, Article 2, which states that states have the right to state sovereignty. And applying it to the present case before us, the state sovereignty that is exercised by the state of Azania is in order to best apply the requisite laws considering the situation within Azania. It is established in the facts that presently the reason why the TWCCA Act was initiated was in order to stop the gross environmental degradation that was taking place in alignment with the informal sector of Azania. To answer your question, the advisory opinion does allow the state of Azania to do so, as specifically at paragraph 280, it applies the due diligence measures that states must take in order to realize these performances. And therefore, it is our submission as counsel for the state of Azania that under international law, state sovereignty is allowed to be used in defense, and to also state that the TWCCA Act was a necessity given the current situation within Azania.
All right. My second question is on a precautionary principle. So the ICJ emphasizes that the precautionary principle regarding climate harm, it emphasizes the precautionary principle. So at what point does a state's precaution become protectionism? So how do you prove that the ban on specific synthetic blends is scientifically necessary to prevent a particular significant harm, rather than just it being just an economic hurdle for foreign investors?
Issue of precautionary principles and prevention, we would like to further cite Article 3, Sub-Article 3 of the UNFCCC, which establishes that the precautionary and prevention principle are necessary. This court, in the case of Herzegovina versus Serbia, further highlighted and defined the necessity of prevention and precautionary principles. With these prevention and precautionary principles, what the ICJ advisory opinion and these cases have stated is that states must prevent, as prevention is better than cure. And that is exactly what the state of Azania has done. We put it to this court that it should not find that the TWCCA Act is protectionist, but rather aligning with international law, as stated previously, that states must prevent any measures that cause that cause any devastating issues with relation to the environment. And therefore, that is exactly what the TWCCA Act and Azania has done. Precaution, as I stated, is a necessary measure and should not be seen as protectionist. And in alignment with the question that you asked me earlier, this is also a principle of state sovereignty, where states are allowed to initiate any measures that they see are necessary at that time, as long as they do not cause gross violations of international human rights. And it is our emphasis as the state of Azania that that is exactly what we have done, not as to be protectionist, but to prevent and cause precautionary measures to be put in place in alignment with international law standards, as well as the ICJ advisory opinion.
All right, thank you, Team Azania. Over to you, presiding judge.
Thank you, Judge. We'll then invite my brother, Judge Okango, Judge Akango, are you there?
Yes, presiding judge, I'm right here. Thank you very much for the opportunity. And I apologize for keeping the court waiting for a few minutes because of traffic. Nonetheless, I want to put the following question to the team. First is with respect to the act in question, which they argue is actually one that is not in any way in contravention of the advisory opinion. And my question is, to what extent?
Judge, we seem to be losing you.
Are you able to hear me now? Are you able to hear me now?
Yes, we can hear you now, Judge.
Yes,
I'm sorry, I think it's network issues. To what extent does the act embrace the technology?
There's a possibility.
You're still losing me?
We can hear you now. Judge, I think there's a possibility that you have two gadgets on at the same time. Are you able to assist Judge Akango?
Are you able to hear me?
Yes, we can hear you.
We can hear you, but there's an echo. I believe you have two gadgets on, or there's just confirm.
My apology once again for the interruption. The question I was putting is with respect to green technology as a way of dealing with the conflict or the possible tension between the environment, as a way of dealing with the tension between environmental concerns and development. To what extent does the Act, or in your view, does the Act make provision or take that into account? I would want you to take that question first, then I move on to the next one.
Most indebted, Your Excellency. Firstly, would like to answer the question stating under the Stockholm Convention in 2004, Article 7 states that every state is legally bound to develop measures in order to satisfy its obligations under international law. Furthermore, in the case of Agenta Foundation versus Netherlands, the Supreme Dutch Court in 2019 held that states have a legal duty to prevent dangerous climate change based on human rights obligation. Answering your question, it is our submission that states hold the absolute power and obligation to ensure that they enact measures that help divert foreseeable climate degradation and harm within an environment such as Azania, which is currently being affected due to the secondhand apparel that imports used and unsorted and stained clothes that end up affecting the green climate in its state. Hence, we submit that international law supports us to take such action, further supported by the advisory opinion, paragraph 282, which states that rules and measures must regulate the conduct and measures within a state, hence obliging every state to enact and take measures that prevent foreseeable harm and dangers to its environment. With that being said, if there is any more further clarification you would like, that is my submission. Thank you. May it please the court.
Thank you. My second question is with respect to the aspect of circular economy. That is, does the Act in question take into account the take, make, and dispose method as a way of reusing materials and reducing waste within the state? Or have you considered that as a possible approach that the state should have taken into account while enacting the law to make sure that as a way of dealing with circular economy, there was a deliberate move away from the take, make, and dispose method?
Most indebted, Your Excellency, may you kindly repeat the question for clarification?
Sorry. When we talk about circular economy as a possible solution to addressing the tension or conflict between development and environment, there is a need to adopt strategies which move away from the take, make, dispose methods towards reusing materials and reducing waste. To what extent does the Act, or does the Act in any way have provisions for that?
Most indebted, Your Excellency. To answer your question, we do believe that the TWCCA Act has worked hand in hand with the idea of circularity and also balancing the interests or the main objective of causing recycling. We do emphasize that we believe that the digital traceability in which we have initiated within the TWCCA Act is efficient. We put this into the consideration of the court, considering that digital traceability is a measure that is adopted globally. That is to say that Azania, by only initiating it now, is actually behind the global standard. And digital traceability involves the issue of identifying clothing materials using e-passports as well as other tenants. We would like to submit that the traditional the traditional mechanisms for circularity are insufficient. And they're insufficient in the fact that, unlike digital traceability, they are not regulated. And as well as the fact that, considering the amount or the number of informal sector actors that they are in Azania, it is not feasible for the state of Azania to continue using this model. And by using digital traceability, it allows for technology to be implemented and to be able to record or show all the transactions that take place that are not feasible at a human level. And therefore, we do submit that the TWCCA Act is in alignment with international law and circularity, as it develops a mechanism through digital traceability that, number one, is the international standard and is the way that Azania is ought to go in order to compete with the interests of the international system that is in place currently. I hope I've answered your question, Your Excellency. Is there any point of clarification that you need at this point?
I am satisfied with that. And another question that I have is, though tied to what my colleague Judge asked your team a little while ago, is with respect to sovereignty. The Act is part of the exercise of sovereignty by the state. And there is the aspect of margin of appreciation, which international law allows sovereign states to have in exercising their policy regulation, or rather policy and regulation. But even then, there has to be some aspect of proportionality to make sure that whatever measures a state adopts do not defeat the object and purpose of the treaty or international law to which the state laws are enacted to enforce. So in this particular instance, how would you respond to the argument that the policy and regulations put in place by the Act are stricter in nature, and to that extent, therefore, they risk defeating the whole object and purpose of international law to which the state is duty-bound to observe?
Most indebted, Your Excellency. It is our submission, and we concede with the court that the TWCCEA Act does not impose a strict nature. It rather considers and allows the governance and partnership of both circular social enterprises and legitimate governance actors. It is our submission, and I would like to cite paragraph 282 of the advisory opinion, which provides in express terms that rules and regulations by a state must regulate the conduct of both public and private actors within a state's jurisdiction and control. It further goes on to state that this must be accompanied by effective enforcement and monitoring mechanisms to ensure their full compliance. We therefore concede that circular social enterprises can be included within the state's governance. However, they cannot hold the full authority, as this is granted by international law to the government. Allow me to cite the Paris Agreement under Article 4, Paragraph 2, which explicitly states that states can prepare and maintain national determined contributions. However, the ICJ affirmed that while the result is mandatory, states have the sovereign discretion to choose the domestic mitigation measures to achieve this. Hence, relating back to your question, there is a proportionate aspect in our Act, as it considers circular social enterprises as ecosystem partners, with the state holding the absolute sovereignty and monitoring of every activities that occurs within a state. I will conclude this by the ICJ case which is held in 1980, where in the case of US diplomatic and consular staff in Tehran, the court confirmed that a state cannot escape responsibility by pointing to the involvement of non-state actors, bringing us back to the argument that a state cannot risk giving its absolute power in abdicating its sovereign duty to circular social enterprise actors, as when things turn tables, the full accountability and liability goes back to the state. Hence, international law recognizes that the state must hold its sovereign duty and regulate every measures and activities that occur within its territory. If you would like more clarification on this, I have given my submission. May it please the court.
I'm okay with the response. Thank you very much, Presiding Judge. I hand it over to you.
Thank you very much. Counsel for Azania, my understanding is that you take the position that the ICJ advisory opinion justifies certain limitations that have been taken by the state to ensure preservation and protection of the environment. I would just want you to address this court on how you would balance environmental protection and human rights, perhaps in terms of international instruments and maybe some regional instruments that you'd want to refer to. I hope my question is clear.
Most indebted, Your Excellency. To provide some clarity for the court, I would like to cite the YTO Korea beef case, where the appellate body, and the citation is WT/DCI 61 ALR, where it dissected Article XXB of the GATT, and it specifically applies to the question that you have asked. This provision provides that limitations of trade can be done to protect human, animal, and plant life. In the present case, we do see that, and that is exactly what the TWCCA Act was initiated to do, not to restrict trade, but to initiate these rights that are owed under international law. This case further provided the necessity test and found that where the interest and values that a court must consider, I beg your pardon, the interest and the values protected by the measure. In the present issue at hand, the TWCCA Act protects not only the environment, but the right to life. Moreover, the only trade impact that is found to be present is the limitation on quality exports. The TWCCA Act initiates provisions that make sure that only quality importations are making their way to Azania. That should not be seen as a restriction, but should be seen as a necessary measure taken by Azania in order to protect its environment. As per page 3 of the facts, if this court is so pleased, it is cited that over 45% of the secondhand clothing that is brought into Azania is unusable. And further, the UN report of 2025 regarding textile waste found that in a situation where 55% of materials are assessed, only 5% of these meet the quality thresholds in the EU. However, if that same 55% is balanced against the measures that are present in Africa, over 50% are considered to be able to be regulated or sent over to Africa. And that just shows that there has been a negligence within the global region as a whole as to creating measures that are necessary to not only protect the environment, but also protect the integrity of trade within the country. If this court is so pleased, I hope I've answered your question, Your Excellency.
Thank you very much indeed. You have. Just a follow-up on that. Azania is a signatory to the other international instruments that address socio-economic rights. Would you want to address your mind, either member of the team, on how that would fit in with the issue of environmental protection, while at the same time respecting human rights, especially the right, socio-economic rights?
Most indebted President, we would like to answer this question responding with Article 12 of the ICESR, which is the International Covenant on the Economic, Social, and Cultural Rights, which explicitly provides that the right to the highest attainable standard of health can only be attained through the protection and prevention and elimination of environmental health hazards. It is our submission that the Toyota versus New Zealand case emphasized that the right to life and the right to health can only be protected when a state takes foreseeable measures to prevent climate danger and I beg your pardon. In the case of Toyota versus New Zealand, the United Nations Human Rights Court in 2022, case number 127D27828, held that the right to life requires states to take positive measures to prevent foreseeable threats to the right to life. It is hence our submission that international law does not require us to balance the right to health and the right to ecological rights. It rather requires us to address both. However, we concede that The right to life is a first human right under international law. The right to life supersedes every other right. We do acknowledge that Azania's current situation has black carbon emissions as well as micropollutants entering into the global system. This clearly leads to the citizens and communities within Azania being involved in drinking and breathing that air. Hence, we submit that it is highly foreseeable that if the state of Azania does not take action in preventing these foreseeable threats that are required in the standard of Toyota versus New Zealand, then we risk destroying the very nation we are aiming to protect. Hence, coming back to your question, we do submit that Azania does acknowledge both human rights and the right to work. However, it starts with first addressing the right to work in order for us to protect the right of everyone and future generations to work. Allow me to conclude this with the case of Waweru versus Republic, where the court held that the right to life can only be enjoyed where there is protection of the environment. Without that, we risk harming the very environment we want economic actors to be operating within. If you need to seek further clarification, these are my submissions, Your Excellency. Thank you.
Thank you very much, Council. I do not need any further clarification. You have communicated very well. I thank you. Okay. We will then now proceed to engage with Council for CECA. And again, as a preliminary, perhaps you just want to introduce yourselves, and then we'll allow my colleagues to put the questions to you.
Good day, Madam President and honourable members of the court. My name is Michaela Dalmedico, First Counsel on behalf of the Coalition for Ethical Circular Apparel, herein known as CECA. I will be dealing with the first three issues. First, proportionality, discrimination, and impact on circular actors. Second, whether second-hand apparel constitutes transboundary environmental harm. And third, whether trade restrictions can be justified under environmental and human rights exceptions.
Greetings to the Honourable Court. Greetings to the Honourable Court. My name is Rihanna Nzele, Second Counsel on behalf of the Coalition for Ethical Circular Apparel. I will be dealing with issues 4 to 6, which deal with mainly whether digital traceability and EPR requirements constitute lawful measures or unlawful discrimination against informal actors, whether the continued exposure of children and coastal communities to apparel-related pollution violates international human rights obligations, and whether social enterprises operating within the circular economy models may function as legitimate governance actors in fulfilling state climate obligations. Thank you.
Thank you very much, Council. I will then now invite my colleague, Judge Cynthia Odongo, to pose her concerns.
Thank you very much, Presiding Judge. So my question to the CECA team, my first question will be in regard to the rights to development. So as CECA, you rely on the right to development for your member organization. So does international law recognize a right to profit from activities that are identified by the ICJ as contributing to a climate emergency that threatens the survival of other states?
Honourable Member, in answering your question, the Council does submit that the right to development under the African Charter on Humans and People's Rights is a major player in why the TWCCA is exorbitant in its approach to mitigate environmental harm. We do believe that there should be a mitigation of environmental harm, but not to the extent in which the right to work under Article 15 of the African Charter on Human and People's Rights is being violated. Council cannot concede to the fact that people living in poverty are not thinking about the environmental impact. They are thinking about the food that they need to have and the abilities to survive. These must be put into question when considering these acts.
Thank you, Michaela.
Greetings to the Honourable Court. Council would like to draw on my co-counsel's submission. While the right to development is an important right, Council for CECA would like to draw the court's attention to a critical distinction. The human rights contemplated before this court arising from apparel-related pollution are not attributable to the circular economy actors. However, they are attributable to the absence of adequate waste management infrastructure. Opposing counsel cited Waweru v. Republic of Kenya. Waweru v. Republic of Kenya. This case recognized that while states have obligations to prevent environmental harm affecting communities, those measures must be proportionate, reasonable, and evidence-based. While the TWCCEA can be deemed to be evidence-based, Council submits that it is not reasonable and is also not proportionate in its current design and application. Thank you.
Thank you very much. My second question is in regard to attribution and responsibility. So if your member companies operate within Azania, they are subject to its jurisdiction. So on what legal basis do you argue that a state cannot upregulate its environmental standards to meet its international obligations, even if those standards were not in place when your members first came in or first invested?
Thank you for your question, Honorable Member. In dealing with your question, Council would like to draw the court to the principle of due diligence, which is expressed in pulp mills on the River Uruguay, the ICJ jurisprudence. This case affirmed that state measures must be grounded in due diligence. Due diligence is an obligation of conduct, not result. Thus, states must be reasonable, evidence-based, and non-arbitrary. Where a regulatory regime selectively imposes burdens on one class of actors without a rational and demonstrable basis for doing so, it ceases to reflect due diligence and becomes discriminatory in character. Thus, in answering Honorable Member's question, the informal actors within the Republic of Azania are subject to the TWCCEA. However, in its current design and application, it cannot be deemed to be reasonable and proportionate, and thus counsel for CECA submits that the TWCCEA be reassessed and redrawn. Thank you.
Perhaps a follow-up question, as you brought up due diligence. So the ICJ uses the word stringent to describe climate obligations. So does this stringency create a new peremptory-like status for environmental law that would probably override standard bilateral investment treaties or trade agreements?
My honourable member, could you please could you please paraphrase your question?
Your co-counsel talked about due diligence. So I'm angling this question on the stringency aspect that the ICJ views or describes climate obligations. So does this stringent nature of climate obligations create a new peremptory status for environmental law that it would override a standard bilateral investment treaty or a trade agreement?
Honourable Member, in answering your question, the 2025 ICJ opinion affirms due diligence as a standard applicable to states in regulating private actors and global value change. Azania's failure prior to the TWCCA to regulate second-hand apparel imports that cause demonstrated environmental harm arguably breached the standard. The TWCCA is Azania's good faith effort to discharge that duty. CECA argues that due diligence also requires procedural safeguards such as consultations, proportionality, and non-discrimination.
Thank you, Michaela and Leander. I think with that, we can move on to the next questions. Honorable Presiding Judge.
Thank you. I will now invite my brother, Judge Akango, to pose his concerns to the team.
With respect to the common but differentiated approach to environmental protection. You're hearing me?
Yes, Honourable Member.
You're able to hear me? Okay, thank you. I'm talking about the common but differentiated approach to environmental protection or regulation, which basically takes into account the different levels of development and possibly even in terms of legal infrastructure that would be obtaining in each and every country. And I want to tie that in with the Paris Agreement as well on climate change, which, though the treaty is binding on the parties, but the NDCs, that is nationally determinable actions, if you like, are left to states to determine as a way of recognizing or upholding the common but differentiated approach to environmental regulation. In this particular instance, do you think the Act measures up to that?
Honourable Member, in answering your question, Council submits that the TWC-CA does not measure up to this. All states have a shared common responsibility to protect the environment, but not equally. The level of responsibility differs based on historical contribution to environmental harm and economic capacity and level of development. Developed states have a greater responsibility, whereas developing states have a lesser or more flexible obligation. Central to our argument, it regards the compensation fund. Industrialized states that produced and exported the textile waste bear greater responsibility. It's also foundational that as a low-emitting, high vulnerable developing state, it should not bear the disproportionate costs of remediation alone. It supports the call for financial mechanisms and technological transfer from global north to Azania.
To build on my co-counsel's argument, I would also like to turn the court's attention to opposing counsel's submission that digital traceability is a global standard. According to the principle of common but differentiated responsibilities, each state cannot be held to the standards of another state. Specifically, developing countries cannot be held to the standards of first world countries. Thus, framing digital traceability as a necessary compliance measure because it is a global standard is not in line with the principle of common but differentiated responsibilities. In the current case, the digital traceability requirements as well as the EPR requirements that are imposed by the TWC-CEA place disproportionate burdens on the informal circular economy actors, which are primarily women and youth, as mentioned in our facts complex. These informal actors lack the technological infrastructure, institutional capacity, and financial resources to comply with digital traceability and EPR mandates. Thus, it is Council submission that the Act creates formal legal obligations that are inaccessible to the very people it seeks to regulate. Thank you.
I'm not sure whether you are
Thank
muted.
you very much. My next question. I believe I'm unmuted now, Judge. Thank you very much. My next question is on the apparent tension when it comes to environmental regulation between poverty and development. The need to industrialize or to develop and improve the livelihoods of people might at times be overwhelming and even pose challenges to environmental regulations or putting in place effective or stricter environmental regulations. How should this balance be struck?
Honourable Member, though Council can understand that there should be frameworks in place to protect both the people of Azania and environmental harm, we believe such standards should be put in place also by those who are causing the environmental harm, not only those that are being faced with it, which can be seen in the polluter pays principle, which also states that those who cause the pollution must contribute to it or contribute to the protection of it or the prevention of it. I hope that answers your question, Honourable Member.
Yes, I'm satisfied with that. And finally, is on the aspect of environmental health, or are you able to hear me? I think there's a problem with my connection a little bit. You're able to hear me now?
Yes, Honourable Member, we can hear you.
Okay, thank you.
Apologies, Honorable Member. May you please kindly restate the question for clarification?
Right, thank you. We just talked about poverty and survival, and you already answered that in response to my question. I want to build on that and talk about global impact. We have, assuming that the act that the state put in place, as we all know, a state's jurisdiction domestically or nationally is unlimited, okay? But the limitation only comes in when it seeks to regulate the affairs or to be exported to affect the operations of citizens of another state, they corporate or natural persons. If this particular act was to be enforced domestically and as it should, and say some transnational corporations or juristic persons operating within the territory of the state would automatically become subject to the regulation of this particular law, would it be open to them to argue, for instance, that this particular law is in conflict or is in direct conflict with the laws of the state of incorporation as a basis for challenging the application of this particular law? I believe you got me.
Honourable Member, CECA submits that in answering your question, Council must first look at transboundary environmental harm. A foundational rule in this is evidently the no harm principle, which originated in the trail smelter arbitration, which requires harm must be proven, substantial, and not hypothetical. Though we understand in these terms harm is evidentiary, there's no evidence showing that less restrictive means were taken. While precautionary principles allow action in uncertainty, it does not justify a blanket assumption of harm without evidence. In reality, a significant portion of second-hand apparel contribute to circular economic practices such as repair, reuse, and resale, which can actually bring in economic value into the second-hand apparel industry through reselling this waste product. The environmental impact varies based on usability and waste management practices and must therefore be assessed. By treating all second-hand apparel as harmful, Azania adopts an overboard and a legally unfound approach.
Thank you, Presiding Judge. No further question from me.
I hope that answered your question, Honourable Member, but if you wish Council to continue about other ways in which unsellable and unusable are differentiated, Council will do so.
I will cede, or I will give my minute to your co-counsel if he so wishes to join in and say something in that respect, but otherwise I'm satisfied with the response that you gave.
Thank you, Honourable Member. In response to your previous question, the solution for differentiated liability lies in the reassessment of the TWCCEA. Specifically redrawing it to target the specific harm pathway at the source rather than creating an overbroad regulation that regulates widely and does not address the specific harm pathway. To target the actual harm, the TWCCEA would have to focus on mismanaged waste rather than regulating imports broadly. This would shift focus to the documented harms that are contemplated in the facts complex, which are landfill dumping, illegal disposal, and open burning. The practical tools for this solution would be licensing for disposal facilities, mandatory waste handling standards, and municipal waste audits. This is found in similar state practice, such as the European Union Framework Directive, which focuses on waste hierarchy. I hope that satisfies Honourable Member.
Thank you, Presiding Judge. Over to you. I hand it back to you.
Very much, Judge. A community that is identified as having to rely on the kind of trade that this legislation seems to be addressing directly, and picking from your arguments that this legislation appears to be discriminatory because of the particular segment of population that is affected. I just want to hear what your thoughts would be with regard to the exposure of children in the whole scenario. How would the children be taken care of? Would you think of any regional and international instruments perhaps that would speak to this and address the court on the issue regarding generational equity, intergenerational equity?
Thank you, Madam President, for your question. In dealing with the question of the continued exposure of children and coastal communities to apparel-related pollution, Council would like to draw the court's attention to the African Charter on Human and People's Rights, which guarantees under Article 24 the rights of all peoples to a satisfactory environment favorable to their development. The African Commission further, in Serach v. Nigeria, affirmed that environmental harm breaches socio-economic rights when it deprives communities of the resources upon which their survival and well-being depend. The Court's 2025 advisory opinion on obligations of states in respect of climate change affirmed that states bear binding obligations under human rights law in the context of climate and environmental harm. The Council for CECA accepts this clarification. However, the facts before this court disclose that between 35 and 45% of imported garments are unsellable and are routinely discarded and burned in the absence of adequate regulatory infrastructure. The human rights violations arising from apparel-related pollution are not attributable to the circular economy actors that the TWCCEA regulates. However, these specific harms flow from the absence of adequate waste management infrastructure and the failure to distinguish between beneficial circular activities and harmful disposal practices. Regulatory responses that penalize the entire second-hand sector without targeting the specific conduct causing harm do not remedy the human rights violation. CECA therefore submits that the continued exposure of children and coastal communities to apparel-related pollution does violate international human rights obligations. However, states are obliged to respond with targeted, proportionate measures that address the specific sources of harm rather than with regulatory frameworks that eliminate the circular economy actors who are mitigating it. In specific reference to intergenerational equity, this principle states that the present generations must not compromise the ability of future generations to meet their own needs. This principle was acknowledged by this court in the Habchikovo-Nyagamaras project as an operative principle of international environmental law. Thus, in taking into account the principle of intergenerational equity, the Republic of Azania is justified in its pursuit of climate harm mitigation. However, their regulatory response must be targeted, proportionate, and context-specific, as affirmed in this court's jurisprudence in Pulp Mills on the River Uruguay. If the court is satisfied, Council would like to rest.
Thank you, Council. I am satisfied. The only other issue of concern, and either of you can respond to this, there are those within Azania who would look at you like busybodies, just out to fight the government for having come up with the legislation. Would you think of any principle that would justify your participation? Like maybe you ought to have been involved in some public participation before the legislation was passed?
Thank you for your question, Madam President. Council would like to draw the court's attention to the facts complex, which states that the enactment of the TWCCEA started in constitutional discussions that further went to the Supreme Court and the African Court of Human Rights, and then which now bring us to our current proceedings in the ICJ. As the Coalition for Ethical Circular Apparel, our participation is justified under the 2030 Agenda for Sustainable Development under Goal 12, which calls on states to promote sustainable production and consumption patterns. However, they should also ensure inclusive economic participation. Regulatory frameworks that exclude informal circular actors from the governance structures designed to address the very harms they are already mitigating are contrary to this mandate. The ICJ's 2025 advisory opinion on the obligations of states in respect of climate change also affirmed that effective climate mitigation requires the inclusion of circular economy actors and cautioned against compliant regimes that unintentionally penalize such contributors. Thus, it is it is a submission of the Coalition for Ethical Circular Apparel that states are obliged to integrate circular economy social enterprises into their climate governance frameworks.
Okay, I don't know whether your colleague would wish to add something. Maybe, are you familiar with the Rio Declaration principles?
Yes, Madam President.
Say something about it. The Rio Declaration, maybe Principle 10, and the place of public participation. Anything that you may have come across?
What?
Can I be heard? Can you hear me?
I apologize, Madam President.
Yes, we can.
Yes, we can hear you. Regarding your question on Principle 10 of the Rio Declaration, it establishes that environmental issues are best handled with the participation of all concerned citizens at the relevant level, which is evident through public participation, and that states shall provide appropriate access to information and opportunity to participate in decision-making processes, such as the implementation of the TWCCA. This obligation applies both before enactment and after enactment, in a continuous procedural duty, not a one-time box-ticking exercise. Instead, CECA's concern is that Azania's parliamentary debate on this record, that the Supreme Court's referral of interpretive questions to the African Court on Human and People's Rights demonstrate that the constitutional challenge was heard and adjudicated. This is in itself a form of participatory governance. The African Court on the People's and Humans and People's Rights ruling affirms that TWCCA confirms that the Act's process and substance met regional human rights standards. However, Azania must concede that if CECA can demonstrate that circular apparel economy actors were significantly excluded from consultation, Article 10 creates a legitimate procedural grievance. Though this does not necessarily invalidate the Act substantially, it would inform the proportionality assessment. The Aarhus Convention of 1998, though not binding in Azania, is still relevant in its information that provides comparative authority for what meaningful participation requires: information provisions, consultations, and access to justice. Azania's response to the TWCCA, it formally recognizes certified circular social enterprises as ecosystem partners under Section 4, which demonstrated that the Act was designed with sector input, but without proper understanding of the informal sector and how valuable it is on the people of Azania.
Thank you, Council. I think that exhausts anything else that I would have had. Thank you very much. I think we now have the rebuttals and sub-rebuttals. And of course, we would then start with Azania, but let the court assistant lay out the protocols. Naomi?
So both councils will have 7 minutes for the final submissions.
So we could start with the council for Azania.
Most indebted, Your Excellency. We would first like to start off by disagreeing with our learned friends for the opposition in regards to the statements that they avert that the informal actors within Azania are not considered to be responsible for the harm caused within the country. We would like to draw on an Indian Supreme Court case, and for clarification, this Honorable Court does allow us to do so under Article 38 of the ICJ statute. And the particular case that I would like to draw inspiration from is the case of Judson and others versus the Union of India of 2025, INSC 1472, wherein the Indian Supreme Court introduced the concept of corporate social responsibility. And with this tenet, it established that businesses within India must perform corporate social responsibility not as a voluntary measure, but as a constitutional obligation. And that is exactly the same precedent and the same stance that is taken within the state of Azania, as we view and has been viewed by the United Nations that environmental protection should be seen as a part of customary international law. And by virtue of it being customary international law, it should not be considered to be derogable. Furthermore, my learned friends had further mentioned the polluter pays principle, and we would like to cite that within this tenet as well, it is established that all contributors to pollution should pay the ultimate price. That is not to say that we view the TWCCA Act as a punitive measure, but however, we would like to submit that it was initiated by Azania as a measure to fully implement the due diligence obligations that are set by international law, such as the Paris Agreements, Article 4, Subarticle 2, as well as Article 2, Subarticle 1, as well as the due diligence measures that are established under paragraph 280 of the ICJ advisory opinion, as my co-counsel previously alluded to. We would further like to disagree with Counsel for CECA, where they mentioned that the mismanaged secondhand clothing should be considered, only the mismanaged secondhand clothing should be considered as waste. We would like to point at an article that was shared in our brother state of Ghana, where the OR Foundation of 2023 found that all waste should, I beg your pardon, all secondhand textile should be considered as waste until it meets its end user. That is to say that until an item of clothing is bought and actually reused, it should be considered waste within the country of Azania. And again, we would like to buttress and say that is exactly why the TWCCA Act initiates the measures that it does, such as EPR requirements and quality control management, to stop the situation from escalating. As a point of reference, just from the UN report of 2024, it was established that the secondhand clothing trade alone contributes to over 90 to 120 million metric tons of waste in a year. As Azania, we do not wish to contribute to this measure. We would not like to contribute to this waste more than we already have, and therefore why it is important that the TWCCA Act be viewed by this court as being constitutionally legitimate and also proportional. If the Honorable Court does not have any questions for me, I would like to cede the floor to my co-counsel to continue our rebuttals.
May it please this Honorable Court. My name is Ms. Kudakuchi Masango, as previously introduced by my lead counsel. We would like to concede that our learned colleagues from CECA mentioned that engaged with the utmost top 3-tier engagement, which is to reuse, repair, and resell. It is our submission that under page 2 of the case file, the environmental reports provide that the secondhand apparel clothes that arrive in Azania, when they enter into Azania, they arrive contaminated, stained, spoiled, and unsellable. It is our submission that these textiles cannot continue to be used in a state that is seeking the same right to work and the same right to life. May I direct this honorable bench to the Basel Convention, Article 4 and 6, which explicitly empowers receiving states to refuse incoming waste. Furthermore, the Basel Convention developments from 2024 to 2025 have acknowledged and classified unsellable waste as, I beg your pardon, the Basel Convention's recent developments from 2025 to 2024 have moved towards classifying unsorted and poor quality textiles as waste rather than used goods. This moves back to our emphasis that the circular economy actors cannot continue the engagement with unsellable waste as it is clearly damaging the environment that the ICJ aims to protect. I would like to conclude this with a famous quote from Edith Waste, a renowned legal scholar, who states that we hold the environment as trustees of the planet. Therefore, honorable members of the bench, today Azania is not asking for this court to permit restriction and permission to regulate. It is asking that this court affirm that international law still protects the people it was meant to serve. We therefore pray this honorable court so holds the TWCCA. May it please the court, if there are no further clarifications your excellencies will need, these are our rebuttals.
Thank you, counsel. My sister, Judge Cynthia Odongo, any interventions?
None from me, presiding judge.
Thank you. Then allow Counsel for CECA to also respond.
Thank you to the Honorable Bench. Counsel for CECA would start by addressing our opposing counsel's argument on whether informal actors are not responsible for the harm that is arising within the Republic of Azania. Counsel would begin with a clarification of counsel's argument. Counsel submits that the TWCCEA does not address and does not distinguish between beneficial circular activities and harmful disposal practices. It is not the view of CECA that the informal sector is not responsible for the harm arising within the Republic of Azania. However, the view is that the TWCCEA is overbroad and does not address this and does not target the specific conduct that is causing harm. Counsel would like to draw the court's attention to the necessity test articulated under the Korea beef case, which establishes that any measure in pursuit of environmental mitigation must be at the least trade restrictive measure. However, it must also contribute wholly to that policy objective. It is the belief of CECA that the TWCCEA is a broad regulation that penalizes the entire second-hand apparel sector without targeting the specific conduct that is causing harm within the Republic of Azania. If there are no further questions, Counsel would like to hand over to my co-counsel to continue with the rebuttals.
In continuing, Counsel submits that the polluter-pays principle is a very essential principle in the way that Azania can afford to mitigate this harm. Azania is a third world country. In this context, it is implementing measures that they do not have the financial backing for, such as the extended producer responsibility and the digital traceability and grading requirement. Excessive funds will be needed to comply these technological advances, funds in which Azania evidently will not be able to procure, considering the economy will be devastated due to the lack of infrastructure from the second-hand apparel sector. We must also contribute that the polluter pays principle directly justifies the EPR regime in the TWCCA. Apparel porters who introduce unsellable garments that become environmental liabilities must bear the cost of their disposal and remediation. The polluter pays principles support CECA's argument regarding a fund should be introduced, a fund that should address the issue of this pollution and those who should contribute should be international environmental figures, such as developed states that historically contribute more to environmental harm, instead of developing states that have less financial and institutional capacity. CECA should propose a circular transition fund, which should be funded by these developed state and global apparel brands, which should be used for this infrastructural development that's Azania evidently will not be able to afford, and gradual compliance mechanisms and capacity building for informal actors. Evidently, we must also look, Counsel submits that there is a difference between unsellable and unusable. A significant portion of second-hand apparel retains practical utility beyond conventional resale markets. In many developing contexts, including Azania's, such goods are repurposed in agricultural settings, such as protective covering, insulation materials, or tools in farming practices. A significant portion of second-hand clothing remains functionally usable beyond resale. Studies by the United Nations Environmental Programme and research on African markets like Ghana show that unsellable garments are often repurposed for agricultural use, which extends their life cycle rather than contributing to waste. In contexts such as South Africa, the monetization of waste systems, particularly through informal waste collection, demonstrate that waste management practices can generate significant economic value while advancing environmental objectives. This demonstrates that circular economy actors are not contributors to harm, but participants in environmental solutions, and that regulation should support rather than exclude economic and environmental beneficial practices. I leave to my co-counsel to pray for relief.
Therefore, CECA respectfully requests this Honourable Court to declare that the TWCCEA's regulations are disproportionate, discriminatory, and unduly impair legitimate circular economy actors in violation of international law. We request the court to declare that where second-hand apparel is mismanaged, states bear due diligence obligation to prevent transboundary harm. However, this obligation must be discharged in a proportionate, evidence-based manner that supports sustainable reuse, repair, and resale. The TWCCEA fails to properly balance environmental protection with economic, social, and livelihood rights as required by the ICJ Advisory Opinion on Climate Change and the Principle of Sustainable Development. The circular economy actors engaged in reuse, repair, and resale must be formally recognized and integrated into state climate governance frameworks, not subjected to regulatory burdens that extinguish their role. CECA further requests any further relief this court considers just and equitable to ensure that national and international regulations are consistent with international obligations and protect the livelihoods of those advancing environmental sustainability. If the court has no further questions, Council would now like to rest.
Thank you very much, Council. I am sorry there is a power surge. Allow me to turn off my camera because I'm sure you can hardly see me. There's a power surge where I am, so the power has sort of declined, giving a dark image. But so I will request that I just turn off my camera, but I'm with you in the session. But thank you very, very much, both teams, for your submissions. Back to the court assistant for further protocol.
Okay, I think that marks the end of the submissions for both sides. So I'll just request the honorable judges to retire from the public courtroom and proceed to the chambers for deliberations. As for the rest of us, kindly remain on the call as we await the return of the honorable judges as they deliver their determination. That's all.
Welcome back. Kindly participants to switch on your cameras. I give you your feedback before I give it back to the presiding judge to issue the determination. So we took a bit of time. I believe this is the session that has had the most feedback. So most of that time was issuing your feedback. It was a very competitive session. And I will issue the feedback beginning with University of Zimbabwe, representing Azania. We start with Lauren Nkahanana. So the bench observes you are very calm and very confident. You have an excellent grasp and understanding of the law and international legal principles. You responded to the bench very well. The bench also observes you are specific in the cited decisions which you are used to submit. The bench also observes you have good mastery of the subject area. The bench further notes that you're articulate and you had a good flow of your ideas. The bench further notes that you understood your briefs and that if you will argue, you will have really defended your case and concisely. And me, this is my personal view, you are on an excellent path to becoming an excellent environmental lawyer in the future. For your counterpart, Kuda Kwashe, knowledge of, you are very skillful in application of the law. You had balanced argument. You are able to look at the challenge in terms of lived realities. You are a good support for your colleague. You are articulate. You have good mastery of the briefs. And then there was good coordination between the two of you. The teamwork and the synergy was well, which the bench observes demonstrated enough preparation between the two of you. And also you were well researched and confident. For Mentors Moot, representing CECA, we start with Luyanda. The bench observes you are confident. However, the bench observes for you and your counterparts, you had some line of thinking, rather a structured format that you expected to present your work. So the interrogative, or rather the inquisitorial nature of the bench derailed you, of course. However, you have good assisting skills. You assisted your co-counsel well. You have good grasp of international principles. The bench also observes you are heavy on case law but limited on regional instruments. The bench also observed that you seemed occasionally off balance, that's just as I've said, but you got back towards the end. You were calm and composed. However, some of your responses were not up to par, the bench observes. For your colleague, Michaela, the bench observes you are calm, but very economical with the use of the law. This comment comes again. It came in the preliminaries, that you're familiar with the principles, but you're not giving exhaustive responses. Your responses are very short. So the bench further observes that those responses are not as exhaustive to give one a deeper view or a deeper understanding of the issues, even though what you are saying is right. But you leave it hanging, so someone does not really follow if you get the deeper understanding of the issue at hand. Again, you lack structured arguments, which seems to be because of the line of questioning. And this, the bench has observed this, that you seem to be getting responses from another source. As the bench asks, it seemed like you are reading the response from another source. So participants need to check on that. And our videos are usually uploaded on YouTube. First thing in the morning, we upload them there so that you can have the benefit to see how the sessions go. However, that is all for my responses. I give it back to the presiding judge to issue the determination. Welcome, presiding judge.
Very much, Dr. Brian Owanda. This is the outcome, having taken into account the knowledge of the law, the application and analysis thereof, the structure and clarity by each counsel, and your advocacy skills that were played out, and also your use of authorities relevant to the situation at hand, and your responsiveness to the bench. Taking all these into consideration, this is the outcome that we have. For Mentors and Moot, we have 70%. For University of Zimbabwe, 82%. So University of Zimbabwe carries the day. Thank you very much. Both teams, thank you for your very good professional approach to the subject.
Thank you very much, presiding judges. There you have it. Mentors and Moot versus University of Zimbabwe for quarterfinal 3. University of Zimbabwe proceed to the semifinals, joining Jomo Kenyatta University of Agriculture and Technology alongside Herbert Chitepo School of Law. Mentors and Moot, thank you very much for the spirited efforts you put. As I tell the others, stay on call, stay on our platforms. We still have much more for you after the Moot, much more trainings and much more legal dialogue on environmental law discourse, and any opportunities we get, we shall always share with you. So we thank you for this. Tomorrow's session, the last quarterfinal match between Egerton University representing Azania and Catholic University of Eastern Africa representing CECA. Same time, same link, same place. Thank you very much. If there's no further issues from the bench, it was an honor to listen to you. And Lauren, you have something you want to say?
No, sir. I just wanted to say thank you for the session to the presiding judge and the bench.
Okay. Michaela, you have something to say?
Thank you, sir, for this learning opportunity, and thank you for allowing us participation in this competition. Thank you.
Luyanda?
Thank you so much to the bench, as well as you, Brian. Yeah, this has truly been a learning curve, and I'm grateful for this opportunity.
Thank you. Kudakwashe?
Thank you very much, Mr. Brian. This was a very insightful mood, and we look forward to more. Thank you so much.
All right. With that, I think we can close it there so that we don't water down those comments. Thank you very much. Have a good evening. You're free to leave the platform.